Good morning. Good morning to everyone. Which class is it, this one? Is it
Civil procedure class, Strathmore Law School? They are second-year law students.
The right connection? So I was making sure that it is the right one.
Okay. Okay. Yeah, you're in the right place right now. Okay. Great. It's a pleasure to have you, Judge. I was just telling the students to highlight some of their expectations, and just a couple of minutes before you joined us, one of the students indicated that the Italian courts,
it's 10 o'clock,
and the Italian judiciary is feared by the politicians. So they said part of their expectations in your submission, in your lecture, you must tell us how has the Italian judiciary and the Italian courts achieved such deference from politicians, because that is something we struggle with back here in Kenya. So I think you can take it away. You can introduce yourself and then make your presentation. And then we will have a question and answer session after your presentation. The students, I know, are very keen on a few things that they have come across in the course of their research in preparation for our lecture today. So up to you, Judge.
Thank you very much for the floor. As I have to introduce myself, I just say to you that I'm Justice for the Italian Supreme Court, which is not the constitutional court, but it's the court which is at the superior level of the jurisdiction, of the ordinary jurisdiction, not the administrative one. And I joined the Supreme Court in 2017, so it's about 3 years that I'm sitting there. And I'm dealing with civil lawsuits and civil procedure. So, and before I got quite an experience in civil law instead of criminal law. But I've done also some criminal law when I was a young judge. You know that in our legal system, judges are formed after law school to be judges at first time, and they pass through public exam, and then they are sent altogether, sent everywhere in the nation as a first course. It depends on the score you get, and then you can choose the ones you like. Fortunately, I was sent at first as my circumscription of residence, and nearby Milan, and so during 30 years I worked around the Milan circuit in North Italy. And then now I have to go to Rome, which is central Italy, where the Supreme Court sits. If you go to Rome, you will see a very nice and majestic building, which was built close to the Vatican City in 1861. After the reunion of Italy. You know, Italy has been declared as a nation only during those times, because every part of Italy was governed by different kings of Spain, kings Austrian kings, and it was all fragmented, a nation very well fragmented. And just to give you an insight of our legal system. So we got the unity, and after that we maintained the free Supreme Court, because there were free Supreme Courts. And in the 19th century, it was all reunified in Rome, finally. So the walk toward the unity of the nation has been very, very slow and hard. But finally, I will say that the Constitution after World War II, the Constitution made the real change. And so that's why today, and now I'm going to face our main topics. I will talk about our experience about constitutionalism in Italy and also in Europe. That has been really the main tool in order to reach the advancement in a democratic sense of the legal system. But, I thank also IALS today because it gave me the opportunity also to think about the importance of real things in dealing with legal topics around the world. It is usually very difficult. We, especially jurists, always think about their own legal system. But during these tough times, I think it's even more important to think about how the legal principle can help us in order to face these very tough times. You see what is happening in England, in the UK, in France, everywhere where there have been the feeling that following freedom, personal freedom, will be the main and the best path to take. It is just the opposite as Italy took during those times, because we thought at first, as we had a very rush experience at first, that thinking, preserving community is even more important than preserving your own personal liberty. And now we are feeling that losing just a little bit of our personal liberty will be the keystone in order to save lives. And so, but we have to make this path with the help of a very strong constitutional text, because it's very easy to slip under to slip towards a liberal tax about from the government. But it's something we experienced at first. There were people who were objecting the government, and now everyone is thinking that the way we took is good, also because the government took emergency laws and norms, more than laws, that were transferred in law. So that through the constitutional rules we have. So at first I want to pass through what it means to have a real text in a constitution. And for IALS, I draw some ideas, and I focus about five pillars that build a constitutional text. I focus about the first pillar, and I thought that the constitutional has to be meant as the backbone of a legal system. We know that in the past times, normative settings and judicial rulings were left to discretionary and extemporaneous regulation, available to whom was governing a submitted community, either by the obvious force of the facts or, at best, an illuminated vision of power. Nowadays, the constitutional norms stemming from a written constitutional or a constitutional tradition represent a unitary set of fixed rules aimed to define, firstly, the structure and the functions of the state apparatus, and secondly, the state power to interfere with the life of citizens and community in general. In such cases, it comes to the role of law and other sources of law to build a legal system complying with the principles settled by the Constitution. In other terms, in the construction of the legal systems, the constitutional rules constitute a fixed legal entity as opposed to the flow of different sorts of legal rules. This is what I define as a first pillar.
The second pillar is about the supremacy of the Constitution, and because the constitutional chart of tradition accompanied by a flow of different sorts of legal rules and principles of law is not sufficient to build a state governed under a constitution. There must be the recognition of the supremacy of the Constitution over the flow of legal rules and judicial statements that constitute the complexity of a legal system. That means that the Constitution, while it justifies its validity, it establishes the primacy of certain rules and values. Historically, the idea of the supremacy of the Constitution over any other sources of law has been first established by the Anglo-American legal system, namely by the Declaration of Independence of July 4th, 1786. Since then, equality among human beings, consent of the governed ones to the governing power, and recognition of unalienable rights to life, liberty, and pursuit of happiness are the basic components of the one constitution also at present times. The presence of those components is essential for the establishment of the supremacy of the Constitution as opposed to the supremacy of existing power, which is the main point to focus on. The third pillar is a constitutional judicial review. The supremacy of a constitution over the sources of law means also that the law cannot contradict the constitutional text. See Marbury versus Madison, Supreme Court of the United States. Therefore, even nowadays, the supremacy of a constitution is evidenced by the fact that a law contrary to it shall be stated ineffective, and that state powers at whatever level are obliged to comply with it by not applying the contrasting law. The presence of an independent constitutional justice capable to assess whether the law complies with it or not, whose aim is not only the adjudication of the unalienable rights and the definition of the state powers, but also the enforcement, this is very important, the enforcement of those rights and the curb of illegitimate exercise of power by central or peripheral organism of the state. The judicial review of laws and rules under constitutional terms, therefore, is the condition for not betraying the role of a constitution as a tool of powers to refrain and enforcement of rights, no matter how it is organized in the legal system. Indeed, even if the way to obtain judicial review of law may change from state to state, it must serve the same purpose. It requires also a reliable and independent judicial system too. That means that also the judiciary has to set certain rules in order to be autonomous from the you know, from the powers, different powers, state powers, and independent. And the fourth pillar is the Constitution as an intangible good as well. Besides the presence of a public and independent authority that works as an impartial guardian and mouth of the Constitution, separation of powers must be the normal way to contain excessive power and the desire to overcome the constitutional chart. Separation of powers means also that the constitutional text is not the book of dreams that has to be stressed, to be realized for the advantage of a few ones to whom it is given, but a living text by which every form of power and shall be inspired. Mainly, the Constitution cannot work as a program of the government, since it can live absurdly in the absence of the government. If we have a constitution, we cannot be afraid about having one government, because all the constitutional text has to provide about also this kind of amendment. That means that the constitutional text works as a general binding law that cannot be changed, although it may be revised by amendments, as we know, passed through rigid protocols and procedures among the different branches of the parliament. For instance, Article 139 of the Italian Constitution prohibits any revision of the Republican form. That means that revisions and amendments can be made in a certain different norms governing internal powers, but not the form of a republican. We cannot transform ourselves in a kingdom, for instance. In other terms, as the constitutional text shall not be betrayed by the existing powers, even if not formally overturned, it cannot be reduced as a sleeping beauty or a dead shell, as I told before, because it is the identity element of a people organized under its basic rules, which is a German, you know, a German feeling about what it is a constitutional text. It is the text that set the basic rules of a nation. The fifth pillar is the international constitutionalism, which is a new idea about the constitution. After the end of World War II, the states strengthened the basic principle of the constitutions by asserting the fundamental human rights in different international binding agreements, such as the Universal Declaration of Human Rights and the European Convention on Human Rights, as I think everybody knows. Even the European treaties have taken this new commitment by incorporating the same principles in the Nice Declaration of 2000, finally enshrined in the European treaties in 2009, that represents the higher form of a new European constitutionalism. You can find in internet all this kind of text and read them. Will be very interesting to see how all the human rights are, you know, are set in such a new chart. Nowadays, it is the common European legal and judicial space more than the single Europe. No, you cannot hear again? Problem?
No, Judge, we can hear you. We can hear you very well.
Ah, okay. May I go?
Yeah, go
on. Nowadays, it is the common European legal and judicial space more than the single European market that is building up a legal area based on mutual recognition, simply harmonizing national legal systems. the role of its two courts of Luxembourg and Strasbourg, and the widespread judicial national review proved as being fundamental in Europe in guaranteeing a common feeling of legal security and enforcement of human rights among European member states. Confidence in the European judicial area is not limited to partial responses to specific emergencies like it works for constitutional national courts, but to statements of principles of law as enshrined by the charters of fundamental rights. This new pattern of international constitutionalism works as a powerful tool to reframe national existing powers by deviating from the common fundamental rights. That is something that is work, incidentally, during these times, because also the Judicial Council of Europe have given some guidelines in order to face these tough times. So let's pass to the part 2 of my speech, which concerns civil procedure during pandemic times. And my lecture is about how to face these times with the through constitutional principles, principles given in the, in governing the procedure. So we have to think about lessons learned and challenges too faced by the judiciary during and after the COVID-19 pandemic. So I think that the best approach to analyze the justice system during COVID-19 pandemic is to inquire on how the new international constitutional principles shall work during that time. The COVID-19 pandemic is a health crisis with serious human and social consequences, physical distancing, not within a state, but among states, social lockdown, stress on healthcare compartment, hard restrictions of personal and enterprise freedom, etc. All factors that lead to government supremacy over the legislative power. We have seen also the government can ban other states the circulation, the right to circulate of people. So, as a positive effect, it has also created challenges, even for courts and judicial authorities in the member states. As regards to the justice system, it invites to reflect on the innovative measures that can arise within judicial systems. During these times, it is interesting to notice that European Commission of Efficiency of Justice, the CEPEJ, it's after a French name, of the Council of Europe, supported the member states in improving the efficiency and quality of their judicial systems in order to ensure that they operate in line with the standards of the Council of Europe and meet the needs of those seeking justice, like right to a fair trial and protection of individual rights. In such a legal conventional framework, every member state has to be the guardian of efficiency, good timing, that means good timing of justice, effectiveness, that means access and quality of justice, efficacy, like quantity of its judicial systems. Member states have made considerable efforts to adjust to new circumstances within a short time and to make the best use of existing resources to ensure the functioning of their courts in a safe environment. Therefore, it is also outlined that they should maintain the momentum and draw the lessons from this experience. Mostly, the crisis cannot be used to excuse deficiency already existing in judicial systems, and even less to reduce standards or breach legal guarantees. Such a health crisis may be repeated, and therefore the judicial systems have to be prepared, notably when it comes to effective solutions to ensure the continuity of court work and access to justice while respecting individual rights. In this context, the CEPEJ reminds the member states of the following important principles enshrined in an official statement. Like, first, the principle 1 is about human rights and rule of law, the respect of those rights. Trust in justice must continue even at time of a crisis. The principles of Article 5 of the European Convention on Human Rights, which concern a right to liberty and security, and Article 6, which concern right to a fair trial, have to be protected at all times and become especially important during the crisis. So the continuous functioning of a judiciary, no matter in which way, and of the services provided by justice professionals needs to be ensured based on European standards. A crisis requires immediate and urgent response, first of all. However, any kind of reaction to the crisis must be strictly based on the principles of the rule of law and must respect and protect human rights. Emergency measures must respect the principles of legality first, legal certainty and proportionality of the measures taken, and need to be constantly re-evaluated as proportioned to the real situation. Judicial authorities, as well as representatives of justice professionals, should, where appropriate, be consulted on the emergency regulations. That means that all the judicial professionals have to be involved in building up new rules. What happened in the Italian legal system? Any measures introduced must have a fixed end date, and judicial review must be possible in due time. So, the principle 2 is access, to guarantee access to justice. During a pandemic, locking down courts might be necessary to protect the health and safety of justice professional and court user, which it is something that happened in Italy during the March and April months. It should be done in a careful and proportionate manner anyway, as it results in an important limitation of access to justice, which is fundamental principle to the rule of law. So the public service of justice must be maintained as much as possible, including providing access to justice by alternative means such as online services or strengthening access to information through court websites and other means of communication like phone, email, etc., which is something that happened all around Europe. Greater consultation and coordination with all justice professionals, including lawyers, enforcement agents, mediators, and social services, will help to ensure a good level of access of justice as well. Access to justice must be ensured for all users, but at time of a health crisis, special attention must be devoted to vulnerable groups who are even more at risk of suffering from the situation. That's why it is important to focus on emergency trials, the trials that had to be dealt, although there is a total a total shutdown of the courts, of ordinary job of the courts. Thus, judicial systems should give priority to cases which concern these groups, such as cases of domestic violence. I give you some examples that are not exhaustive. Domestic violence, in particular against women and children, involving elderly people or persons with disabilities, or concerning a serious economic situation and also criminal law as well. Vulnerability arising from the crisis should also be taken into account. Principle 3 is about safety, to guarantee safety of persons. Ensuring the health and safety of all the justice professionals, as well as of the users in courts, must be a priority during and after the health crisis. We have to change mind about this, because we are used to be all jammed in the courthouses. Now we have to change this path. Safety measures need to be put in place to respect the necessary physical distancing within the court premises. All measures need to be prepared in a consultation and explained clearly to all concerned, regularly evaluated and adapted to the new circumstances. They may require additional investments of money in the court infrastructure as well. So teleworking should be open to justice professionals. They should be provided with the necessary secure IT equipment, which happened in Italy as well, because also the government gave some funds also to lawyers in order to improve their own IT equipment. Particular attention needs to be paid to their well-being during teleworking, and in particular to the fact that these are exceptional working conditions which may require appropriate support. Exceptional, but can be, I will add that they can become also ordinary ones as the IT equipment and technology will improve in time. So it's just an experiment that we have to use for exceptional working, but I think that in the future it will be the way of alternative working in different, in different contexts of legal procedures. So the fourth principle is about monitoring case flow, quality, and performance during these times, allowing for the better and flexible allocation of resources as close to local realities as possible during and after the crisis is instrumental in ensuring the emergency functioning of the courts and preventing any aggravation of existing difficulties within judicial system. We have to make everything easy during this time and giving very clear rules in order to work in such a different context. The well-functioning case management systems and mechanism of statistical data collection concerning the functioning of the courts is especially relevant during a health crisis. Court presidents, judges, and authorities responsible for court management should continue to monitor and manage cases according to their responsibilities, even remotely. So we have not to fear about the remote trial. We have to set very clear rule on how to deal with it. This includes triage of cases and possible prioritization and redistribution of cases based on objective and fair criteria and ensuring quality justice. Given the number of cases that could not be processed and the adjournments of hearings, human resources and budgetary support should have course to put in place a plan to absorb delays, which is something that is quite hard in certain legal systems because the centralized government governs all the money, all the funds. And especially in Italy, there is not an autonomy in spending money by the single tribunals. So they have to wait for dispositions by the government. But now it's working even in such a way because we have emergency law. And so Principle 5 is about cyber justice. The recourse to information technologies offers the opportunity to the public service of justice to continue functioning during the health crisis. Ensuring cyber security and the protection of personal data must be a priority. However, its rapid emergence and excessive use may equally bring negative consequences. IT solutions such as online services, remote hearings, and video conferences, as well as future development of digital justice, must always respect fundamental rights and principles of a fair trial, which is also a neutral trial and a trial that respects personal data and doesn't allow people to see what happens in a civil trial, during a civil trial. And because, you know, there are a lot of problems about protecting the personal life of people. And so we have to ensure all this. To reduce risks inherent in the deployment of IT, their use of and accessibility for all the users should have a clear legal basis as well. Special attention should be paid to the most vulnerable groups in this respect, as I said before. And the impact of the use of these technologies on justice delivery should therefore be evaluated regularly and remedial measures taken when necessary. So there is another principle about training, which is even more important during this time. Training is fundamental for the effective management of the health crisis in the future. So judicial training should adapt to the emerging needs, including the use of IT. New curricula should be developed to support justice professionals during and after a health crisis. The closure of courts and the lockdown measures put in place can allow justice professionals to devote more time to training from home in a safe and secure environment, which is something we have done in Italy because there have been a lot of chatting through lawyers and judges and so on. So it has been a very interesting and special experience for us. Training institutions should develop the use of e-learning platforms as well. Specific training of teleworking should be provided for justice professionals. Specific training in the new types of cases arising from the COVID-19 pandemic should also be provided for justice professionals. Let's think about the breach of contracts. We have a rising amount of cases about breach of contracts, like labor contracts and so on, and also concerning every kind of business. So we have also to be trained on how to deal with these cases as lawyers and judges. Working with legal rules, that are not thought about about working during pandemic times. You know, the concept of impossibility to perform in a contractual way has to be reevaluated, the concept of impossibility. Justice professionals should be consulted by competent institutions, including via online surveys, on such specific training needs. So just let's say, as an example, what we have done in Italy in this field. Training has been considered very important, and also the Superior Council of the Judiciary provided for courses for judges, online courses, in order to discuss about how to deal with the cases, civil cases during these times, and how to use the IT softwares provided by the government, because the judiciary is not allowed to use their own personal software. They have to use the ones provided by the government. The government chose Teams instead of Zoom. I know that Zoom works much better, but Teams has been supposed as the best tool in order to guarantee privacy and personal data protection. I don't know why, but there has been more trust in Teams solutions. And so we have to work with Teams, and I don't know if we used it to try to use the Teams environment is not so suited to deal with civil proceedings, because it's good in order to make conferences and to let people talk, but it doesn't provide a way in order to see all the scene of what is going on. So the experience was that these tools are very limited in the use and don't provide a good environment for civil proceedings. The feeling of the Italian judges is that those software are good in order to discuss within each other and to discuss with lawyers without the presence of witnesses or the parties, because when you have to judge the parties, it is a different way. You need something more powerful in order to give you all the scenes. You need, that the trial is supposed to be an instantaneous moment where everything is acted in front of a judge, as in a theater. So unless we have IT solution that give this performance, we are always very limited in the role of getting persuaded by what is happening in front of you. So that is the experience so far we had, and that's why, at least at the Supreme Court level, we decided to stop about going on with a distance trials, and we are going to join. As an example, I have to go to Rome and to participate to our hearings in a normal way, because it is important to guarantee all this kind of environment, which is an environment, procedural environment, especially at the Supreme Court level. And so Principle 7 is about forward-looking justice. The COVID-19 pandemic has also been an occasion to introduce emergency innovative practices with all the limits I said before. A transformation strategy for judiciary should be developed to capitalize on the benefits and newly implemented solutions. Some aspects of traditional court functioning should be reconsidered, like relations with media, level of use of new technologies, increased recourse to alternative dispute resolution, in particularly to mediation. Transforming the judiciary for the future should be approached in a positive manner and always with respect for fundamental rights guaranteed in the ECHR Convention. It would also be appropriate to maintain the necessary dialogue between all actors in the justice system and to take advantage of the new relations created between judges, prosecutors, court staff, lawyers, enforcement agents, notaries, mediators, and experts at the time of health crisis. So let's try some conclusions. The pandemic interval is too long for being dreamed in terms of a general suspension of constitutional rights and right to a fair trial. First, access to quality justice must be enhanced with alternative means, supportive administrative staff, and sufficient funds as well. The most important political gesture to be done by justice operators like lawyers, judges, and administrative apparatus is to govern it and leverage of its initial curbs through constitutional principles. That's why I talked before about what are the constitutional principles as set by a real and true chart. Thank you. Thank you to everybody.
Judge, thank you very much for that very insightful lecture. We have certainly picked a lot that we would have even recommended for our own judicial system here in Kenya, because the COVID-19 pandemic has of course affected even our justice system here. I think Italy has proven, I think to my mind, as an example that we can defer to in finding ways in which the justice system needs to go through some sort of a change to at least reduce the effects of the pandemic.